be seated. We have but one case on our docket for today, and I assume counsel understands the way the clock operates. Mr. Wheeler or someone else has explained it to you. When you see the time running, it will not take into consideration your rebuttal time for the appellant, so you need to be aware of that. Are counsel ready? If so, counsel for the appellant.
May it please the Court, Russell Kent for Attorney General Bill McCollum, appearing on behalf of Appellant Secretary of State Kurt Browning. I would like to reserve 5 minutes for rebuttal. Your Honors, as the joint motion for expedite indicated, the Duval County Supervisor of Elections has set a September 8th ballot printing deadline. I think I can speak on behalf of both parties in expressing our appreciation for the Court's expedited consideration of this appeal. This appeal involves the trial court's order granting a writ of mandamus against the Secretary and ordering him to certify appellee as a candidate qualified for election to the House of Representatives, District 17. The two issues on appeal are essentially whether the Secretary has an indisputable legal duty to accept qualifying papers that do not meet statutory requirement, and secondly, whether the Secretary can be stopped to determine that candidate has not qualified based on an employee's statements at the filing desk made on the last day of qualifying. The facts of this case are undisputed. The Secretary has accepted the facts as found by the trial court for purposes of this appeal.
Counsel, it seems to me in reading the briefs and the cases that are cited there, that at least as it relates to the first three, to the mandamus issues, that your argument is I think primarily related to the remedy of mandamus. Would you take issue with the fact, if I made this assertion, that under Florida case law, a technical error in a notary's acknowledgement is not a basis for excluding someone from the ballot?
Your Honor, I would take issue with that statement respectfully.
Well, then what does Siegendorf mean if it doesn't mean that?
What Siegendorf means is that deference is given to the determinations made during qualifying by the Secretary of State or by other qualifying officers.
But is that what the court said? Didn't the court really go out of its way to talk about technicalities should not be a basis for keeping somebody, for really excluding the voters from making a decision about a candidate?
Your Honor, certainly that language is present in Siegendorf, but Siegendorf is in a very different context.
I fully agree with that. I understand how you've attempted to distinguish it. It's a different set of facts. And I'm not saying Siegendorf stands for the principle that your client is obligated to accept a form that is technically defective. I'm going to another point, and that is whether or not under Florida law someone can be kept off the ballot. I can come back to the mandamus for a minute, but let's assume we had here, instead of a mandamus action, a declaratory judgment action. So we didn't have the issue of what your client's responsibilities are in accepting this paper. Would we be looking at sort of a different law to apply?
Your Honor, if that claim had been pled below, obviously the law would be slightly different. I believe the outcome would be the same. Under the case law by the Florida Supreme Court, going back 60, 70 years, candidates have the obligation to comply with the election laws. And Siegendorf did not change that, in my view. So it perhaps might be a closer case on declaratory judgment claim, but the claim made below, and the claim litigated was for mandamus. If I could.
Well, I understood Siegendorf, and correct me if I'm wrong, to sort of accept the notion that there can be such a thing as substantial compliance, and that we wouldn't keep a candidate off the ballot for a technical and minor error, such as the one that was committed in the Siegendorf case. Or do you think it's more narrowly focused on you just can't force the Secretary of State to make the decision about what it is or is not substantial compliance?
Your Honor, my view of Siegendorf is that the substantial compliance doctrine relates to a case brought by a candidate after the Secretary of State has qualified another candidate, seeking to have the candidate essentially disqualified.
Oh, so are you saying now, see if I have this right, are you saying that this doctrine can never be used by a candidate who seeks to get on the ballot who's been rejected by the Secretary of State?
Yes, Your Honor. I do not believe Siegendorf addresses that issue at all. In fact, Siegendorf.
Well, I know it doesn't, but I mean the principle in the case. You're saying it doesn't apply the other way?
I believe it does not apply the other way.
Let me ask you this. I think you've made, if I understand it correctly, I think you've made a compelling argument in the brief that the Secretary of State ought not to be in a position of having to decide what does or does not constitute substantial compliance, because that's really sort of more of an adjudicatory function. And I can see how your office or the office you represent would get in trouble by trying to make judgments on this kind of thing. Are you more worried about that, or are you more worried about whether this woman can qualify? In other words, if there's a way that she can qualify, and let me just be very frank with you. I see a way in which both sides can win this case. It seems to me that that maybe if your main point is that your office ought not to be put to the task of having to answer writs of mandamus about making what amounts to judgment calls about what does or doesn't qualify. And I think that's a very good argument. If that's your point, it seems to me that the court might be able to validate that point and still allow the candidate to run, because it seems to me that she has a good point too.
Your Honor,
maybe the problem is she didn't have the right to insist on you granting her relief.
Your Honor, I do see that as the problem. The Green case in the notary context deals with a failure to comply with the notary statute. And the court there indicated there are remedies. There are other cases cited in our brief. But back to your main point, this case has, with all due respect to Apolli, never really been about her. It has been about having objective standards for reviewing qualifying papers and for making sure.
What should she have done? Let's assume you're correct. And I've already told you, I think you have a good argument about mandamus. What should she have done?
She should have filed her qualifying papers well before the last day of qualifying. She came in 30 minutes before the close of qualifying. As a practical matter, if problems are not caught there, the qualifying period will end, and in the case law it's quite clear that there's nothing that can be done.
Well, so you're saying not only she has no remedy in mandamus against you because this is not a ministerial duty, but she has no legal remedy at all. Is that what you're saying? Your
Honor, my position is that the Secretary would have prevailed even under a declaratory judgment type of claim, because the statute says that the Secretary should make reasonable efforts to contact candidates about mistakes in their qualifying papers prior to the last day of qualifying. In addition, prior to 1995, there was a provision in the election laws that if problems were discovered in qualifying papers, the Secretary was to inform candidates and give them 72 hours to fix those problems. There must be a reason why the legislature went from that point of view to the statute as it's written now, which says prior to the last day of qualifying, the Secretary should have this good faith conversation and try to essentially encourage candidates to comply with the election laws.
Counsel, one of the arguments made by the opponent, your opponent, is that it is irrational for the Secretary to take the position that if a candidate walks in from Duval County with a notary form that says County of Miami-Dade, and you know that's wrong, the candidate is from Duval County, you happen to know the notary is from Duval County, you know the form was signed in Duval County, but because it says a county, then you have to accept those papers. But County of Florida, because it doesn't exist, you have the right to reject those papers, even though in both cases the notarization is flawed.
And Your Honor, Chapter 7 in the Florida statutes list what are the counties in Florida. But under the Chevin v. Stone analysis, the Attorney General opinion 8050, even if the secretary or other qualifying officer has independent knowledge that factual statements made in the qualifying papers are incorrect, he or she cannot act on that knowledge. So
the basic policy of the state is, excuse me for interrupting, your position is then that the secretary performs a ministerial duty, accepts papers that are valid on their face, and will qualify such a candidate, and it is entirely up to third parties to challenge those candidates in a separate legal action. That's the remedy.
Your Honor, that's the remedy if the qualifying papers are in proper order on their face.
Right.
The difference here is that you could look and see that Florida is not a county. Duval is a county. It is the wrong county, but it is a county, Your Honor.
Counsel, you're down to just a little over 4 minutes.
But in Siegendorf, there was a defect that was at least as bad, wasn't it? I mean, the candidate didn't even say what office he was running for. Said running for judge, Group 3. He didn't even say Dade County. I guess they knew it was Dade County because he came from Dade County and wrote a check on a Miami bank account. But the papers, if you want to talk about the legality of the papers, wasn't the error there just as bad? The error that ultimately allowed a candidate to run on the ground that it was too technical to stop him. Wasn't that just as bad as the error here, or even worse?
Your Honor, with all due respect, I would say the Siegendorf error was far different. The statutory requirement there was to state the title of the office sought. The candidate stated it, perhaps not as elegantly as he might have, and the secretary determined that the statement essentially satisfied the statute. Here, Applee has conceded that she does not meet a statutory element. Her brief, on page 23 of the answer brief, she says she meets 6 out of the 7 statutory elements. So here, there is a clear failure to comply with the statute. The Form 6 is a required qualifying paper. So I would say that this was somewhat more serious than Siegendorf. If I could, I'd like to reserve my remaining time for rebuttal.
You'll have about 2.5 minutes.
Good afternoon, and may it please the court. I'm John Mills. I filed an appearance kind of late in the day. Mr. Collins is at the convention, so I've endeavored to take over. If I could back the court up, obviously you're understanding most of our arguments, and I don't want to rehash what you just said, but I'd like to take a step back. There's no election statute, there's no election regulation that requires a notary, much less that requires the county. They require a sworn statement. That's what the Constitution requires, that's what the statute requires, that's what the regulation requires. Now, in implementing the regulation, the statute that requires it to be a sworn statement, and the regulation that requires it, the regulation says full and public disclosure of financial interests. That's what the language the Constitution requires. Means filing a sworn statement showing net worth, assets, and liabilities on the form prescribed by the Commission. There's no dispute here that she did that. She complied with the statutes. She complied with the regulations. All she didn't comply with was her notary filled out a form incorrectly that had extra information. You didn't have to have a notary. There's all kinds of sworn statements that courts accept and that businesses accept without a notary. Prisoners all the time, they don't have notaries in prison. They're allowed to file sworn declarations. It's still a sworn statement. So the legal issue here is, does the supervisor or does the Division of Elections have the ability or the right to reject an application where all of the statutory requirements are met, all of the regulatory requirements are met, but a form that they have approved has an additional piece of information that was incorrectly filled out?
But counsel says that you have conceded that this was a defect. Is that not true?
I don't think we've conceded it. It's a defect in that it's incorrect. There's no Florida county, and this wasn't signed in Florida County. But we haven't conceded that these papers were defective under the law. In fact, we've sought mandamus saying they comply with the law, and there's an affirmative ministerial duty to accept them. Now, the ministerial duty, I understand the concerns that are raised by the appellant and Judge Padovano that you've raised.
And we're talking about substantial compliance, the doctrine of substantial compliance. I'm sorry, but I don't see any way that can amount to a ministerial duty, because it would necessarily involve some judgment or some adjudication of whether the exception should be permitted to apply. I don't rule it out in a case like yours, but I really can't see how the Secretary would have that duty. But now, help me out here, because I think
they've interpreted their duty that way.
We're talking about different cases. It sounds to me like what you're saying is that there is no defect. If there is no defect, then mandamus is a proper remedy. If I filed papers that were perfectly proper, and the Secretary of State said to me, we don't like Italian Americans, we're not going to accept your papers. Mandamus, no one would argue it. Mandamus is proper because there's no reason to reject those papers. But a different situation is presented entirely if we're talking about substantial compliance.
Sure.
And I gather you're not talking about that at all.
I'm talking about both. I'm talking about it in the alternative. Okay. And to some extent, I may be articulating a reason in support of the judge's decision below that wasn't fully articulated before. But I'm the appellee, and I'm entitled to do that. And I think that you don't have to get to the substantial compliance issue if you look at the fact that the statutes themselves and the regulations, everything was complied with, and that's conceded. The only thing is this county. And the county, you won't find that requirement in the Florida Administrative Code, in the Florida Statute Book, or the Florida Constitution. It's on a form. They have a regulation that says we approve the use of this form, but the form could have all kinds of extra stuff that's not required by the statute, and I would suggest that they can't make new requirements just on a form and deny an application when all of the statutory and regulatory requirements are met. And I do think it is, I think the court has already understood there's a big difference, even if you put that argument aside, there's a big difference between leaving it blank and putting the wrong word in. And in fact, this exact candidate at the exact time had two notarized documents that she submitted. And one, the person at the counter said, that's difficult to read, but we've got a notary right here, let's stamp it again. They stamped it, and that notary wrote the wrong county in. Undisputed, wrote the wrong county in. They say that's acceptable. But putting the wrong name in, you've still filled it out, you've completed everything in the form, you haven't left it blank, you've attempted to complete it, and it's not even the candidate attempted to complete it. It's an officer of the state, a notary, attempted to complete it, and they wrote the wrong word in.
This has not been brought up in the briefs, but do you think the underlying rationale of that form is to allow venue to be established in a potential perjury prosecution? No, I don't think so at all. I mean, I think you would have venue by the place where the person lives, even if they signed it somewhere else. And if it was, whose decision was that? That was the decision of whoever came up with the form, because the election code doesn't require it. You know, they keep saying that we need to defer to the agency that's interpreting the statute. The statute they're relying on is the notary statute. Courts interpret that all the time. That's not an election statute. The statute that says it's 117.054A. That's the statute that says if you're going to notarize something, you have to put the venue. That's where the requirement comes from. And maybe in some places, maybe that's going to be relevant. In this instance, there is no relevance to it, particularly in light of the admitted fact that a Leon County notary is fine. There's nothing wrong with that.
In the Siegendorf case, the court has a bit of discussion in there about the fact that the task of administering election laws is one that can't be performed without the exercise of some professional judgment. In fact, said the secretary is I think the phrase they used, in the field, and has the right to make some judgments about whether something is good enough or not good enough. And that was one of the reasons that they gave for not granting the writ of mandamus in that case. Does that sort of work against you here in this argument?
Sure, it does to some extent. I mean, obviously that is a weakness in our argument with our remedy, you know. But this is in the nature of an appellate remedy. You're seeking to challenge an action, and it perhaps should have been brought as a deck action. And if it had been brought as a deck action, with seeking a declaration that this complies with all statutory requirements, then we omit that issue altogether, and we're at the same place that the judge reached.
Well, that brings me to another question. We can treat an appellate remedy that's incorrect as if it were done correctly, but can we recharacterize a trial court remedy?
Well, it's the trial court acting in a somewhat appellate capacity, in a review capacity. It is reviewing a decision of an administrative agency. And it's doing so through a writ that is governed by the rules of appellate procedure. And the rules of appellate procedure are what tell us that if you seek the wrong remedy, you can treat it elsewhere. Admittedly, it's not super clean. It's not like it should have been an appeal instead of should have been treated as a notice of appeal instead of a petition. As a deck action isn't normally considered a pure appellate action. But I think the same, the rules of civil procedure say that they're to be interpreted to...
I guess your point is that nobody can argue that they weren't on notice of the kind of relief that you were asking for. I mean, whatever we call the form of the remedy...
I mean, all you have to do is pick up the paper and read the story of this case. Everybody who reads it knows the issue in this case is if you put Florida instead of the county, do you lose your ability to get on the ballot? And Siegendorf also talks about the importance the Florida Constitution begins with the proposition that the political power belongs with the people. And here we have an elections agency removing the power of the people to vote for a candidate who complied with all statutory requirements.
Counselor, how do you address the policy arguments raised by the Secretary that to affirm here places that officer in the very unattractive position of constantly making these decisions about whether or not somebody's truly qualified? They walk in and let's say there's some other defect. We can come up with a million examples. And everyone in this room knows that during elections there are always going to be situations where there may be, as in this case, a person who's there at 30 minutes before qualifying. What do you say to that argument?
I say you do what you always do. Do your best job, and if there's a question, it'll be litigated, and the court will determine it. That's what the courts are for. And in most cases that came here, I mean, there were 10 times this came up. They have a statutory duty when it's submitted ahead of time to attempt to get things cleared up. And they keep hammering Ms. Young on, well, she came in at 11:30 right beforehand. It was her third time she came in. You know, she came in, she tried to comply, she came in, they said, no, now this is too old, you need to get an original of this exact form that we're talking about. You know, they called her at 5 o'clock the night before. You know, so she had done everything. She just hadn't gotten the file in this particular paper.
So if the secretary's standing there at 10 till noon and looking at your client's form and your client's back on I-10 heading back to Jacksonville, and the secretary looks at it and says, my goodness, this county of Florida, this is an error, but you know what? I'm going to exercise my professional judgment and qualify the candidate regardless of the defect. Do you think that's within his purview? I'm
not sure. I mean, you're talking about exercising their professional judgment. Their point is they don't have the ability to exercise professional judgment. I mean,
they do.
Their point is this is it's a technicality and we're sorry, but we've got to comply, even though they recognize it as a technicality. Anybody could recognize this particular one. It doesn't take professional judgment. You could ask anybody out on the street, would this give them the facts? Is this just a technicality? Or is this substantial compliance? I mean, I understand those are legal terms, and there may be instances where that's more difficult to determine. And maybe in an appropriate case, that's grounds to deny a writ of prohibition or of mandamus. And again, the other answer to your question, I think, is that the better remedy to seek, and the more appropriate remedy perhaps that should have been sought in this case, is a simple deck action. And in a deck action, you don't have those issues. We have to have an interpretation of the statute.
Counsel, go ahead.
We had a case recently and issued an opinion where a candidate had failed to provide a resign to run letter.
Right.
He made the argument that he had substantially complied. He'd had a press conference. He told the world he was a candidate for the State House, actually, in fact. And everyone knew. In fact, people filed to qualify.
Right.
Everybody who was interested in that seat qualified, purportedly. And the trial court said, no, you did not file your, he was challenged, and said, no, you did not file your resign to run letter. That candidate made a substantial compliance argument that was rejected by the trial court and this court. You see that as different?
Yeah, I see that as very different. I mean, if Ms. Young, the analog here would be if Ms. Young did not file the form altogether. It's a required form. If she hadn't filed it, instead said, well, I held a press conference and I told everybody all of my financial disclosures. Everybody in the world knows all of what I have, so I've complied with the purpose of the statute. You know, I think we would lose that case because there is a statute that requires specifically several forms. That's one. This is one. This is a form that is required to be filed. And no matter what everybody else knows, the official record doesn't have it. When I say anybody looking at this, anybody would know, any reasonable person would know, I'm talking about one thing only, looking at the piece of paper that she filed. And by looking at that piece of paper, any reasonable person is going to say that's substantial compliance. That's at most a technical violation. And again, it's a technical error in filling out a form. It's not an error at all in providing any statutorily required information.
Counsel, the appellant relies in part on the Grime case, G-R-I-E-M, where a deed was set aside in part because of a problem with the notary acknowledgement. How would you distinguish that?
I'm not recalling right off the top of my head what the flaw with the notary.
Well, in that case, actually,
that case, the party did not appear before the notary, and the notary nevertheless executed the acknowledgement saying the party had appeared, and the party contested.
Well, I mean, that wouldn't apply. I mean, here we're talking about the facial validity of documents. And so, I mean, by their own admission, they don't go beyond. I mean, if it says Leon County, even though, if it says Duval County, even though they just, I mean, this person was standing right next to her, just stamped it in front of her and wrote the wrong county in. I mean, if that's their position that you can't go beyond that, then certainly I don't think that case would apply for the same reason. All right, well, if there are no more questions, I appreciate your time, and I do join in thanking the court for expediting this matter.
Thank you, Counsel.
And you agree that September 8th is we have to do something here before September 8th, right?
I have no reason to disagree.
Well,
I don't, as a personal, I have not verified that, and in fact, I did not verify that with Mr. Collins. I understand that to be the representation that he's made, and I do not dispute that.
Before you start, could you just clear up one thing for me? Because it does, Mr. Mills' argument kind of puts the case in a little bit different light than I thought it was in. But he's saying that there's no requirement that this be notarized, and that as long as it was sworn, it meets the requirements of the law. Now, you know, I expressed some sympathy for your point of view about mandamus if this were a substantial compliance. But if it's not a substantial compliance, if his argument is that she did fully comply with the law, and you're just adding extra requirements, you know, then of course that would be a different case. Could you address that for me and maybe clear that up? And you don't agree, I guess.
I do not agree,
Okay.
Your Honor. And certainly, I understand Mr. Mills just joined this case. But on page 23 of the answer brief, the statement is, the subject notarization contains 6 out of 7 elements. There's another statement, only 1 element was omitted. So I don't believe that to be a live issue, but the issue is incorrect. Under Section 112.3145, the legislature directed the Commission on Ethics to set up forms for these filings. And by rule, they established Form 6. So I don't know how you would get around that. It is a
Your
requirement.
argument is if it's part of the form that was required by law and approved, then it's required.
Absolutely, Your Honor. That's certainly how the Secretary interpreted the law, and that interpretation would be entitled to substantial deference. I think it's also the correct interpretation. Also, heard for the first time that the appellate rules of procedure might control. I've had to deal with this issue from the Civil Procedure Rules Committee side. This is a case clearly controlled by Rule 1.630. Judge Cooper did not consider himself to be reviewing a decision. He was conducting a trial on the merits. And the tipsy coachman doctrine, at least in my view, does not apply to matters not raised below. And there was never any mention of declaratory judgment. Appellee chose to frame her case as a mandamus case.
Let me ask you a question aside from that, if I may. If you had accepted this qualifying candidate's papers and said she is qualified, and a third party had come in and challenged your authority and said, that form is defective and this candidate must be removed from the ballot, and a circuit court agreed and removed her from the ballot on the basis of putting Florida down, in that situation, should we affirm or reverse?
Your Honor, I see that my time is up, but if it's okay, I'll answer the question. Your Honor, I would still think you would reverse. Again, it would be a much closer case given the deference given to the Secretary, but I would still think you would reverse because it would be a failure to comply with a statutory requirement.
Okay, so the Secretary accepts the papers, finds the candidate qualified, circuit judge orders the candidate removed for putting Florida instead of a county. We should affirm or reverse? I'm sorry.
Yes, sir, I'm sorry if I was unclear.
I apologize.
You should affirm the decision by the trial court. It would be essentially the Varn case, the decision that substantial compliance was not shown. If I could, I would ask the court respectfully to remand the case and with instructions to reverse the decision below. Thank you.
Thank you, counsel. Thank you both.